If you don't do that, there are consequences. There are very significant consequences. There was a term that was coined at CAI nationally by one of the founders of CAI nationally close to 40 years ago. And when he coined that term, I said to everybody that was present at the time, that's going to be our downfall. It's the worst thing he could have possibly done by creating a term that he thinks is important to make people understand their obligation, but I'm telling you will all be used against you at some point in time in the future. I was reminded of that when I started going to CAI, the CAI Council of Community Association Lawyers annual seminar, again a few years ago, by one of the other old-timers that's been around as long as me, and he said, I remember you telling everybody 25 years ago, this is going to be the bane, it's going to be a problem for all of us. And what the words were fiduciary duty. That's the term. And what this court said, and it's law in Illinois, is you all have fiduciary duties if you're on the board. And if you do something that is inconsistent with your fiduciary duty, whether you think it's knowing or not, if the court determines you should have known better, they're going to hold you responsible and accountable. And although it didn't happen in the case, in the Palm case, you potentially and maybe actually can become personally liable, and the association can't and won't indemnify you, nor will the insurance that you have through the association indemnify you. So I want you all to understand that. It's not a threat. It's not meant to be a threat. It's meant to be, to a certain extent, a warning that the court in Palm has established a very high standard, because everyone up to now has been using a standard that was at the ground. And that standard under Palm is not acceptable. I was at a meeting last night explaining it to a homeowners association, a non-condominium, and one of the board members said, I'm going to resign. And then the second one said, I'm going to resign. I don't want that liability. My answer to them was, if you feel that strongly that you can't work in the environment that you're obligated to work, and by the way, the two people that wanted to resign were high-level executives in a major stock exchange listed company. Okay? I couldn't believe that I'm listening to them say that to me when they knew what the rules were in what they do every day in their business. Okay? Said, if you have to do that, you have to do that. But now who's going to run the business of the association? And they said, oh, we got on the board because the people before us weren't open and were hiding things and were doing things that we didn't understand and that we didn't know, and were imposing charges that nobody agreed upon, and they were passing rules and just doing things summarily and causing all kinds of problems. So we kind of got rid of them, and we're pretty open, as a matter of fact. I said, so what's the big deal? So we only want to have 4 meetings a year, and we want to do everything by internet, because that's what we do in our business. I said, not everything. You're a public corporation. Oh, all right. Well, they got quiet. Nobody resigned. And we got through an awful lot, actually, and we came up with workarounds, solutions, things that have to happen. But you understand, workarounds and solutions are just that. If you ask me today whether it'll work, my answer is, I think so. If you ask me tomorrow whether it'll work if you're being sued, my answer is, think twice about it, or if you think you're going to be sued. And if you ask me whether the court tomorrow is going to rule somewhere that some of the workarounds are not good, my answer is, I think it is potentially likely. Because the court basically said, run a business like a business. Be open. Make sure that everybody understands what that means. So with that, I think it's important that I explain to you a little bit about the Palm case so that you understand the history. I didn't bring it with me. If you want, I can get you a copy of the appellate court decision. I can get you a copy of the 17-page decision by the trial court judge There has been a petition for leave to appeal to the Supreme Court that was filed last month by one of the other law firms in Chicago that is heavily involved in condominium associations. I have looked at their petition. I don't think they did the best job they could have done. I wasn't asked to write it. I didn't have the time to write it. I didn't have the desire to write it. I didn't want to put myself in the spotlight. My partners didn't have the time or the inclination. It was very nice that it was done. Well, we haven't yet done an amicus brief. I'm also a member of the Illinois Legislative Action Committee, and I'm a member of CCAL, which is the College of Community Association Lawyers. So that's through the national CAI. So we may yet, if the petition is accepted, we may yet have an opportunity to do what's called a friend of the court brief, an amicus brief. And who knows who will participate in it. Hopefully we can do one that covers all of the bases better than the brief that was submitted by the law firm. Now in the trial court case, there was a law firm that was involved that actually is doing association work and doing litigation for 20 years. But in my opinion, from reading the case at the trial level, they didn't do a good job of preparing the 3 or 4 witnesses that participated at all. And one of the worst parts of all of that was what this chief financial officer will tell you is a horrible problem for associations on figuring out what to do at the end of the year with your financial statement. That has had all of us more in a quandary than all of the other issues put together that are dealing with the Palm case on what to do with excess money that's in the account, and because of what was said in that case. So that's a little issue that nobody even knows exists out there. So we got a trial law firm that had 20 years of association experience, but didn't do a good job for reasons that I don't understand. The brief at the appellate court was done by that same law firm, as I recall. The petition for leave to appeal was done by another law firm. And one that I would have thought would have done a better job. Now, at the trial level, the judge in the Circuit Court of Cook County is Judge Sophia Hall. Judge Sophia Hall has been a judge in what's called the Chancery Division, which is the highest level, for 30 plus years. I have appeared before her over those 30 years, and my partners have appeared before her over these 30 years on a number of occasions. In a condominium association case, she will tell a defendant in the case. Most of the cases we appear before her in Chancery have to do with foreclosures, usually, or covenants violations. You know, the bird feeder on the balcony that is attracting all the pigeons that are dropping poop on the balcony below. You're laughing. But I got to tell you, that was one of the cases. The person with the 50-pound dog that they were starving to get down to 25 pounds because under 25 pounds you could keep the dog. Oh yeah, I mean, you know, and she would sit up there in her chair and at her table, at her bench, and she would look down at everybody and she'd say, I know condominium associations and I know condominium association law, and I know the plaintiff's attorney. They're knowledgeable attorneys. They've been doing this for a long time. I know the law because I had to buy my mother a condominium, and I bought her the condominium, and she got sick, and she was no longer there, and I had to keep the condominium because the market changed, and lo and behold, they made me a member of the board, and then they made me president. So I've been running this condominium for about 10 years now, and I know all the issues that exist in this condominium. And I'm telling you that so you understand what's coming. And she'd say that more to the defendant than to us. I never lost a case before her. I won the bird feeder case, we won the dog case, we got injunctions, we got attorney's fees. All big decisions. Every case we ever had before Judge Sophia Hall, we won. Every attorney I know, in any case dealing with a condominium, won every case before Judge Sophia Hall except Palm. Okay? Are you all getting the message? All right? Now, I can't tell you that it's only the law firm, because in reading the case, I think we had facts from hell, plaintiff from hell, board from hell, about every perfect storm condition that you could have, all came together before the wrong judge. And she knew that everything was wrong and just responded to it the way she probably should have. But the result of that is terribly strict law. Bad facts applied to the bad law creates bad law, very frankly, and that's what we have here. When you read the facts and you hear what people said before the judge during the case, you realize that you had an out-of-control group of people. Mr. Palm, by the way, is a retired attorney. Mr. Palm sat on the board for more than 10 years. Maybe he was the president, it's unclear. At the end of that period of time, for whatever reason, he got off the board. I imagine he was removed because they didn't like him. And from the day he was off the board, they never told him another thing about what was going on. No matter what he asked for or asked to see, they didn't give it to him. A retired attorney on the board, removed from the board, anxious to know what's going on, locked off, not let go. Not a smart cause of action. There was a Palm 1 case. Palm 1 case was he asked for records. The Illinois City of Chicago ordinance provides that you got to give records in 5 days. They didn't give him records in 5 days. He sued for access to the records. He got access to the records and he got attorney's fees. That went up on appeal. He won it on appeal. That went down after the appeal, and then we had the second case. This is the second case where he sued them for breach of duty, for failing to have meetings, for failing to have open meetings, for failing to do things at open meetings, for having workshops, for using electronic communication, and all of those things. Now, there weren't facts, but there was a 4-day-long trial, and the president testified, and I think the treasurer testified, and I'm not sure, I thought there were 4, but I don't remember who the other 2, but it was 4 days, and the president and the treasurer testified. And the president, of course, being examined, oh, by the way, Palm has since had his unit foreclosed before Judge Sophia Hall in the same court. His mortgage has been foreclosed. I'm not sure if he's out or still in, but it's already gone through the sale. Because my partner Jim was in court the day that they were doing a confirmation of the sale. Now they put it off. They didn't decide it that day because there were some other issues. They may have appealed on that. But, so you understand, this is a whole convoluted case. And this guy wasn't paying his assessments, it appears. And it may not be. He certainly got foreclosed on his mortgage. I will say he was on a walker and he was sitting on the walker and talking to it, according to my partner who was in court at that time. He still won this case. So understand, put all the pieces together. A lot of elements here where you got a lot of angry people fighting, and it's people that who knew what they were doing. Obviously, he knew how to prepare some of the suit material, how to do a lot of things. They criticized everything he did and the fact that there was no record, and then he won. So what he did couldn't have been as bad as what they did to him in the court's mind. What does that tell you? Not enough disclosure, nothing open. They didn't like all of those particular facts. Okay, so what are the key components? And there are a lot of them. There's no one really big thing. But I think I'll start with what the court said is the way you have to operate. The first thing that you need to understand is the court said that you can have an executive session, and in an executive session you can only do the 3 things that are identified in the Condominium Property Act. And if you're not a condominium and you're a common interest community association, the same thing is in the CICA, Common Interest Community Association Act, on this issue as is in the Condominium Property Act. They're pretty much the same on a lot of the things that apply in the Palm case between both acts. I meant to bring both. I gave instructions for them to put it in the box. The box had 100 copies of the Condominium Property Act, no copies of the Common Interest Community Association Act. If you want a Common Interest Community Association Act, go to our website, www.dicklerlaw.com. It's there. You
You got to drill down through a couple of the information stuff, or call my office, send an email to me, marshall@dicklerlaw.com, and we'll send you out copies. All right, as many as you want. We'll send you out copies of the Common Interest Act. But on this part, it's both the same. There are basically three things that you can discuss in executive session. You can discuss actual or potential litigation, the hiring and firing of employees, and unpaid assessments and fines and penalties. Those are the three subjects that you can discuss in an executive session. And after you've discussed them in an executive session, you must come out of executive session and in an open board meeting vote on anything you're going to do with respect to any of those matters that you've discussed, if there's something that has to be done. So if you're talking about a rules violation, you have to come out of executive session and vote to fine the person, fine the people living at 85, whatever this address is here, all right, St. Paul Church, all right? Fine the people at St. Paul Church for whatever the violation is. Now, the question becomes, do you have to name a name, and is that a problem? And my answer is, actually, it isn't a problem. We've all told you not to disclose anything that you shouldn't disclose because we tell you there's always a chance that somebody's going to file what we call a slap suit for defamation. Does it have any merit in an association or in a golf club or a private club or anything like that? It has no merit, but why take a chance? Every conservative attorney will tell you, don't publish. So when you come out of executive session, instead of saying a name, use an address. Identify it as resolution number 1 with respect to property at this address. How do we vote? Do we vote in favor of a fine? Yes. Or against the fine? Do we vote to turn over the matter to the law firm to start collections? On collections, the easier way to do it is, because everybody says, what do we do about collections? We got to vote on it. Well, my first answer is pass a rule. And the rule is X amount of days of delinquency, it gets turned over to the law firm. Period. The other night I was asked, well, what if there's all kinds of hardships? My answer is, if you're a condominium, hardships don't count. You cannot refrain from pursuing recovery of the monies. It's right in the act. There are no ifs, ands, or buts about it. And everybody looks at me like I'm a monster. Well, I guess I'm a monster. You know, you understand what this case kept on saying is you're obligated to follow, which I ought to put into print. This case basically said you're obligated to follow the act that applies and your declaration wording. If you don't follow the act that applies and your declaration wording, you will be found to be in breach of your fiduciary duty. Period. That's what happened in this case. They didn't follow the declaration wording. They didn't follow the act wording. They didn't do what was required of them under the act and under the declaration. If you were required to do something and you don't do it, or you don't do it the way they tell you to do it, you will be in breach of your fiduciary duty. Now, I started with the 3 items, and I want to break back and tell you that one of the issues in this case at some point in time was Mr. Palm entitled to money for winning? And where there's a breach of fiduciary duty. And at least one part of the court case basically said, very interesting question. Mr. Palm sued basically to get what's called injunctive relief. The court wanted the court to stop them from not doing what they were supposed to do and require them to do what they were supposed to do. He never asked for damages. He never had a separate request for damages. He never had a separate request for attorney's fees in that case. If you don't have a request for damages and you don't have a request for attorney's fees, the court's not going to give it to you. It's got to be a part of the case, not something separate. It's always part of the case. He never asked. The court said he never asked, so we didn't give it to him. He never asked. The reverse of the logic there is, had he asked, They would have given it to him. In this particular case. Not only that, and they kind of said that in a backhanded fashion. Not only that, they then went on to say, and the association, since they were in breach of fiduciary duty, the board, since they were in breach of fiduciary duty, the board might not have its insurance there in place to cover that cost and may have personal responsibility. And any other indemnification provisions in your declaration wouldn't apply because it was breach of fiduciary duty. I will tell you the trial court actually went farther. The trial court actually said it was gross breach of fiduciary duty. Gross breach of fiduciary duty. Well, those terms actually don't fit together because breach of fiduciary duty is, it's breach of your obligations by law, and when you start using the word gross, it's like negligent. So it's like negligent breach of contract, which they don't fit together, but it was said by Judge Sophia Hall to emphasize how serious she thought the breach of fiduciary duty was. She exaggerated it by using the word gross breach of fiduciary duty. And I think, and the appellate court, when they looked at that, said damages would have been allowed. It wouldn't have been covered by the indemnification provisions of the declaration. It wouldn't have been covered by your insurance policy. And yes, the individual board members could have been on the line. But he never asked, so we didn't have to decide. But they told you what they would have decided had there been a request. Guess what's going to happen in the next lawsuit? There's going to be a request. You don't want to be the defendants in that lawsuit if you haven't done what's required by the Act or what's required by the declaration. Am I making my point? Now, I don't want you to leave, and I don't want you to get off the board. I just want you to do what you're supposed to do by understanding what the documents say and what the Act says, and do what the Act and the documents say. Going back to the three exceptions, the three exceptions are actual or potential litigation. If you and I were talking privately and I was at a board meeting and we went into executive session so you could talk with your attorney, that's confidential and privileged, and all the case law says that. If you're there without me and you're talking about the potential for litigation because you're worried about a lawsuit with some of the unit owners, you could talk about that in an executive session. You're going to sue that unit owner because they've got their hedges in front of the 30-foot line, and you're going to stop them from having it there. Or you got to stop the bird feeder because the bird feeder is causing all kinds of problems with poop on the balcony below, and people are getting sick, and you need to deal with it, which is the more significant one. You know this person's going to defend because they're an attorney and they want to do what they want to do. So let's talk about an executive session. You talk about it in an executive session, you can say what you want. The purpose for executive session is to allow you to say all the things that you think are dumb, that are probably not dumb, that you're normally afraid to say or shouldn't say in front of a bunch of people. All right? Unfortunately, I have association boards that say those things in public, and I try, shut up, please. Close your mouth. But those are the things that you're supposed to be able to say. I think that person is a bad person. I've heard a rumor about that person. I've heard that they've been sued for theft, or they've stolen some money. I don't trust that person. You could say those kinds of things in an executive session, and you're okay. If you said it in an open meeting, you'd be sued for defamation. All right? You could even say, you know what? This kind of contractor is, in my opinion, from my investigation, shady. I think the contractor takes the money, puts it in their pocket. You may or may not get the work done. You're certainly not going to get it done well. Now, if you think that that's an okay statement, I'm going to tell you it probably is, but it's bad enough so that somebody could sue you over it. And you want to say that maybe in an executive session. Now, everybody says, but now you're talking about a contract. You are and you aren't, because now you're talking about the potential for litigation with the contractor that you're looking at hiring, and you're worried about it in advance, and you want to find out what the ramifications are. Or you got a contract in your hand, and there's a paragraph in that contract, and you don't understand it, and you want to talk about the legal ramifications of that contract paragraph. You can talk about that in an executive session. If you want to come out of executive session and there's something to vote on, we're going to go after the person who's got the bushes within the 30-foot setback line. And I've been involved in that suit out here, as a matter of fact. The answer I'm going to give you is you got to come out and vote on it in an open meeting, and vote in the open. Now, you can say, you know, Unit 4 or Unit 5 or whatever it is, we want to proceed on the motion with respect to this matter that we wrote up in executive session. Municipal governments do that because you don't want to broadcast you're going to sue that person, particularly before you get the suit on file, in case there are some other issues that come up, or in case they file a countersuit first, or whatever you want to do. So, can you say we want to vote on resolution number 1 in executive session? That's what municipal governments do. Up to now, it's been okay. If you ask me whether it's still okay, the answer is I don't know. Because, and I don't know. I mean, I don't know anymore, because the way the cases are written, they want more transparency than less. I'm almost of the opinion that if you want to be safe, you come out of executive session and you say, we're going to vote on Unit 1, whether or not we're going to sue. I move that we proceed with turning it over to the attorney, starting the litigation process, and proceeding with the litigation process. And second, all in favor, vote. And you vote on that at that point in time. Now, if you ask me whether you're broadcasting, my answer is yes. People are going to know soon enough if they're going to file a countersuit and try and do something, or they're going to stop what they're doing. That may be a way of helping get some of the things done that you want to have done. But the focus seems to be more of transparency rather than lack of transparency. Is there a question?
Yeah, a question. If you come out of executive session, can you recommend as a board that you go this way? In other words, the board gets out of executive session and you go to the board and you say, the board recommends that we, yes. Can you do that?
The boards that we recommend?
Well, let's say you want a litigation against owner number 1.
Right.
Okay. And you come out of the executive session and then you put it up to the board and you say, the board recommends we go ahead with it.
Yeah.
You can do that.
Sure.
Okay.
But you have to say, the board has to actually vote on it. And so somebody has to, at that point in time, I don't know who you're saying that to, because you've got a board in place, and the board at that point in time is actually voting on some kind of a resolution. So someone has to make a motion to vote. Someone has to make a motion to vote on passing it. And so it's not that the board is recommending, and you're not asking the unit owners, because the unit owners have nothing to do with it. This is a board of directors meeting. Maybe I need to step back and say, because I'm all of a sudden finding that people don't know the difference between a board of directors meeting and a members meeting. A members meeting is like once a year to vote on the board, the people on the board. The board of directors meeting is what you hold to conduct board business. In a condo association, unit owners don't have a voice or vote in a board of directors meeting. The board conducts all board business. That's actually true in a non-condominium also, except in a non-condominium, you got to give them some time, you got to give the unit owners some time to talk. So you can do it at the beginning of the meeting, you can give them 3 minutes each for anybody that wants to talk, or at the end of the meeting, but usually at the beginning of the meeting, so they can say what they want to say. You can say, thank you very much, we're taking it under advisement, and let them leave. They do not participate in the activities of the board or in any of the actions of the board. Yes?
So what you're saying is that our condominium association does not have to allow at an open board meeting the unit owners their right to have an open unit owner?
They have no right, they have no voice and no vote in any actions of the board of directors.
They have no vote.
They have no voice. They have no right to talk.
They have a right to a unit or an open forum?
They have a right to an open forum if you give it to them, but it has nothing to do with any of the board business. You can give it to them. They have no inherent right to it in a condominium. In a non-condominium, they do because the statute specifically provides for it. It isn't in the Condominium Property Act. That's all they have a right to is come and sit and listen, recorded by an audio recorder or by a video recorder. They have no right to participate, to say anything at that meeting. Lots of times boards do let them do it, and your board, in fact, has let them do it because they want it to be a little bit more participative. But there is no obligation, there is no right. And usually what it does is it disrupts the business of an association. Sometimes they do it because they want more, it brings people in and gives them an opportunity to participate. As a general statement, it's disruptive. The meetings go on a lot longer. There is no right to participate in either a condominium or non-condominium in the decisions or actions of the board. None. You're the board. You do what you're supposed to do. So it's not that you're making a recommendation, because you're not making a recommendation to the people out there. You've got 5 board members. If there are 5 board members, somebody, the president, usually simply says, someone make a motion with respect to resolution 1 in the executive session, just like you would on any other action. And somebody will say, I move that we proceed against this address, and turn it over to the lawyer to proceed with action against this particular unit owner and this unit for the violation that exists. Anybody second it? Yes, you get a second. All in favor. Technically, you don't really need a second. You can take a vote right there, but everybody that is makes the motion, seconds the motion, passes the motion. Next item in the executive session. And you go through all of them. And that's at an open meeting where you come back out.
But does homeowners have to be there after the executive session for you to vote on that?
No, they don't have to be there. If they've left,
right.
If they've left, they're not necessary. That's all you have to have is a quorum of the board. So the fact that they've not been there and they don't hear anything, they don't know it. However, they will be entitled to see the minutes, and you will have it in the minutes. So that will identify in the future what occurred, because that part is public. That part will be available in the future.
Do you have to have minutes for the executive session as well?
You don't have to have minutes of the executive session, but you have to have minutes of the vote,
right,
of what you did that came out. So you still have to identify it.
I'm pretty sure in the law that says you have to have an executive minutes.
There is nothing that says anything about an executive session in the statute. Nothing. Not one word. Any word. So we've gotten through that. You know, I'd like to get through some of this, and if I answer all your questions, I'm going to help you, but I'm not going to get through a lot of the issues of the palm case. So I'm trying to tell you, we've talked about the executive session and what can be addressed in the executive session. Anything that has to be voted on, any decision that is being made has to be made outside of the executive session in an open meeting. I don't care whether there are unit owners at that time left that come back or not. You have to do it in basically an open meeting. If there's somebody standing at the door and wanting to come in and was waiting to hear what you're going to do, you got to let them come in and sit and listen. They can record it on a recorder like this machine. They can put it on a tape recorder. They can put it on the table. They can leave it and ask you to take it with you at the end of the day if you would. And of course you could say, sure, you don't have to commit. It's really their job. You don't have to do that for them, but you might want to just be accommodating. You may want to record it yourself so that people could see it. You may want to record it and put it on a internet channel as a part of your disclosure to all the people and having it available. So all of those things you can do. There's no prohibition. All of that adds to better disclosure. But those are the 3 items you have to talk about in executive session for all practical purposes and nothing more. Now, what the court said was, this is the way we read the statute. And I will tell you, they turned it around from what all of us that were involved in the statute when it was drafted and put in place in the 90s understood it. Because up until then, it was, well, you can't discuss anything except at a meeting. And the answer was, oh no, there are things that we have to discuss, and we want to do it. And every attorney that has been in this practice for a long period of time will tell you that their focus has always been that everything is fair game in a workshop. Everything is fair game in a workshop, except you can't vote. Voting is conducting business. That's what we've all said for 30 years. And everybody was in agreement, was consistent. Well, this court said we were wrong. What this court said was, and they took apart parts of the act, the different parts of the word, and some of the changes to the act where they put in this section and took the different wording apart, and they said, as we read this, and based upon the changes in the wording and the changes in the act, any discussion of board business, any discussion is a discussion of board business, okay? And if you're discussing board business, it has to be at an open meeting. Now, they did limit it in this case. They did say that any quorum of the board, majority of the board, discussing any association business is conducting a meeting. So, if you're a 5-person board, and you have 3 board members together, and you talk about the dog that wasn't carried onto the elevator, or the dog that pooped in somebody's yard, you're talking about board business. And if you haven't sent out a notice that you're going to talk about it at that time and place, on the street, and let everybody come there when you talked about it, and complied with the statutory notice, you are in breach of your duty. Now everybody says, well, how could we, you know, that means the 3 of us can't get on the elevator sometime together. And the answer is, okay, that's an extreme example. And it is an extreme example. And we joked about it. I mean, 30 years ago, the standard joke was, in high-rises, there were rules that you had to carry your dog if you had a dog on the elevator. You couldn't have the dog on the ground because the dog on the ground, half the time the elevator started going and the dog started peeing. That was pretty typical. So one of the ways to get around it was you had to carry your dog, which helped and prevented it from happening because the dog wouldn't pee on its master, as you all stated. There's a problem if you had a 50-pound dog and you lived on the 10th floor, but that was not the association's problem. That was the unit owner's problem. All right, either train the dog or find it, or walk it down, or do something and back up a good exercise. So, you know, the standard joke was 3 board members on the same floor, the elevator door opens and there's a dog on the floor, and they all look at it and say, violation, sorry, it's not a meeting, it's not an, you've just established a violation in violation of the requirements for an open meeting under the Act, and it's an invalid violation or determination, and you can't proceed. And we joked about that 30 or 40 years ago. Well, to a certain extent right now, it may not be a joke. It may be a problem. Now, does that mean that you couldn't identify it at that point in time and then raise that as an issue as board members that you witnessed a violation, send out a violation from the management company or notice a violation, and come to a meeting at the next meeting and let the person appear, tell their story for whatever it is, and then decide if there's a violation at the open board meeting? The answer is certainly you can. Do I think it's going to interfere with your operation? No, but you understand, 3 board members out of a 5-person board, any quorum, if there's 5 and it's a 9-person board, any quorum together, and you start talking about the landscaping being a mess, you, for all practical purposes, are conducting board business. Now, what's the limits of that? I don't know. I mean, if you're all walking together and talking about stuff, is that really necessarily going to be a problem? I don't know. If you're out there looking at the landscaping and trying to decide what you need to do, and you're discussing that, is that going to necessarily be a problem? I don't know, but I will tell you, based upon this case, it is, at that point in time, if you have a quorum of the board together, it is basically discussing unit owner business. And the way this case is written, if you can only do that at an open meeting called for that purpose. Now, how does people go around and do stuff in that kind of environment? And my answer is, look at your documents. Can you establish committees? If you can establish committees, have a committee. Most of the time, you can establish committees. Have a committee with 1 board member, maybe 2. Depends on the size. If you've got 3 board members on your association board, 1 board member, and 1 non-board member. All right? That committee, through the board member, can report to the board what they find. We went around, we did all the landscaping. You say I can't get another group together, my answer is it's going to be a committee of 1. Or if it's a 5-person board, it could be 2 board members that could be part of the committee. And if you could find a non-board member, get a non-board member. Put it all together. That's part of the workaround. All right? There are workarounds. So, and then that group, that person or that committee can report to the board, just like a municipal government does. And they can say, here's what we found from what we looked around. And you got at least one doing all the legwork, or a group doing all the legwork, and reporting to the entire board. That is not conducting board business as so far as we can see today, based upon our analysis of this case. So, do you accomplish the same result? You accomplish the same result. What about the other kinds of issues? One of the other things that the court said was, interestingly enough, well, your declaration gives you, and the Condominium Property Act and the SECA Act gives you the power and authority to delegate certain things to management, certain decisions. And there are all kinds of decisions you can delegate to the management company, and it's okay. Now, in this case, the court actually said they did it wrong, because the condominium, their declaration for this association said, a majority of the board of directors has the power and authority to delegate certain functions to the management company. The management company's contract said the management company had the right to do certain things if delegated by the board up to X amount of money. Okay? So the management and the court said the board had the power to delegate certain activities to the management company. The management company contract gave the management company the right to do certain things based upon a delegation. All of that was in place. What the board did ultimately was said, okay, we as a board, by majority vote, authorize the management company to do the following acts after they first checked with one of the 3 people, the president, the vice president, or the treasurer, and gotten their approval. So we went around in a big circle and got approval. They had to get approval from one of the 3, basically, officers of the association. And their declaration said you can delegate authority by board action, and board action required a quorum of the board and a majority of the board. So a majority of the board delegated it, but then took it back and gave the authority to one board member. Do you follow the circle? Last couple of times I've said it, and everybody kind of looked at me and they didn't follow the circle. The court said, you gave it and took it back. And you took it back incorrectly. And you can't do that. The board is the one that has the authority, not the individual member of the board. You can't go around in this circle. So they could have delegated it, and they didn't do it right. So I'm telling you, there are things you can delegate. Now, let me give you the example that I like. Of course, it's the rule that nobody wants to hear. The example I like is you establish a rule, and the rule is collections are turned over to the law firm 60 days after, when they're delinquent 60 days, whatever the amount is. Now everybody says, well, we got to have a hearing, we got to listen to their story, whatever the story may be. And I'm saying, in a condominium for sure no, because you're prohibited from not pursuing collections. In a non-condominium, it doesn't have the same word in the act, but I don't think there's any difference in the application. My answer is, there is no requirement that you necessarily vote on each one of them. You can establish a rule saying, 60 days delinquent, turn it over to the law firm. 75 days delinquent, turn it over to the law firm. If there's a management company, you can say the management company, which is what I'm saying. Manager, 60-day delinquent, it goes to the law firm. You don't have to ask us again. Send it to the law firm, send them a ledger, we're done. So you don't have to vote on it at every meeting. It's not a subject of the meeting. Manager will report back to you, these are the delinquencies I turned over to the law firm at the meeting. They can identify it, it's in the report, here's the cases. They can even give you a report of what's going on and where they stand and what they've been done at that time. It's all what the management is reporting. You don't have to vote on anything. You've passed the general rule. Can you do that on other things? The other question is, what about architectural control? You have standards? I mean, the one that came up last night was, we got people who want to change the doors, they want to change the door colors. I said, do you have any standard procedures and rules that you pass you can buy these 4 doors, this particular style from this manufacturer, and you can have them put in by one of these 3 or 4 contractors? Can we do that? Oh, sure you can do that. And you can delegate that approval process to the Architectural Control Committee. Again, you got a committee, 1 board member, Architectural Control Committee. And the Architectural Control Committee will get the application with the information from the management company, from the manager, we'll review it, meets all the criteria. They don't even have to vote, they don't have to decide anything. So all they have to say is, it meets the criteria. The board's already approved it. So all you're doing is asking them whether it meets the criteria. If you're asking me whether that shaving hairs is compared to the other one that happened in Palm, my answer is, yes, it's shaving hairs. They're kind of saying that's okay, because you're not really asking for further approval. It's all you're asking for is from the committee, which is part of their job in almost all of these architectural control committees, is does this meet the standards that you've identified and defined? Does that put some work on you? The meeting I was at last night, the board also said, you know, you're right. So all we have to do is give them the choices that we think are okay, put it in the form. And about half of the associations I represent actually have that all set up like that. So all those kinds of standard things, all those standard issues, yeah. All right, we live in a high rise and you have things that break every month. You give the manager authority to deal with emergency situations. I'm dealing with things that break that need to be replaced up to $5,000. In today's world, it used to be $1,000, probably used to be $500, but today, you know, they just upped it to $5,000. Okay, you know, you're living in a high rise, if one of the chillers breaks, chiller's $30,000 or $300,000, you better have a board meeting. And you better then pass on that one independently and get a couple of bids and do all the other things. But if you have something that breaks that needs to be fixed and it's a couple $1,000s, you know, a filter on the swimming pool has busted and you gotta get the filter replaced. You don't wanna wait for a board meeting in the middle of the summer and shut the pool down. You want it fixed. You want the pool guy to come out and fix it tomorrow, today, if possible. It's under $1,000, it's under $2,000, boom, you've given them authority. Those things that you know are within the standard. If you want to specify things, you can specify. If you want to say, all right, you've given authority if they show you, if there's a tree that's identified as dead, and we have to replace the tree, you're authorized to replace it with the same kind of tree if it's allowed and it's not an emerald ash, you know. Which, you know, you can't replace them with any more ashes, they're gone. You got to replace them with somebody else, something else, and you identify it. You can buy the tree from this nursery for under $1,500. You're authorized. Boom. Just do it. And it's authorized. You don't have to have a meeting for that. And I could go on and on and on. Just think that way. What things, if you're going to delegate to the manager, delegate to the manager, all of these things. That's part of the manager's ability, decision. That's why I have a manager. These are all things within the realm of what they should be able to do pretty easily. And that's what you do. Now, one of the other things that was happening in the Palm case, and everybody is up in arms about it, is all the board was communicating by email. Okay? That's what you're all here to hear me say, huh? No, no, no. No more. We're done. We're done. And it's not that some people don't have email and don't do it, but I understand. I mean, I helped create this. I worked at Motorola. I'm one of the people who was involved with creating this. It was created before the internet, then they figured out how to put the internet on the damn thing. And you know, now we don't live without it. And don't know how to live without it. And everything is instantaneous and everybody expects it to instantaneous results. And that's the way they want to work. And the answer that I'm going to give you is, it doesn't work in a condominium and homeowners association anymore right now. And I cannot tell you that it will change tomorrow or the day after. Because you're not conducting a public meeting. You're not conducting an open meeting. Period. You're just not an open meeting, and it doesn't meet the criteria for an open meeting. Can I find a way to make it an open meeting? Probably, and I'll tell you what my theory is on the workaround, but let me carry it into two things. In a condominium association, one of the things that Palm said was, the statute says you have to mail notice post it around the property at convenient locations, or mail it 48 hours in advance of the meeting. Now that's for a board of directors meeting. Everybody says, no, no, our documents say 10 days or 15 days. That's a members meeting. That's a unit owners meeting. That's not a board of directors meeting. If you're a condominium, a board of directors meeting, you only have to have 48 hours notice. And you have to post it around the property or send it by mail. They use the internet. They use their internet website for sending notice to everybody. They said it was okay. I will tell you that every attorney out there said, no court's going to rule that that's not okay. In today's world, it's going to be okay. Every one of us said that. We were wrong. We were 100% wrong. The court said, mail is mail. Internet is not mail. Email is not mail. Mail is U.S. mail. Not delivery, because it didn't allow for delivery, because they actually deliver to some of the people. All right? They mailed to off-site. They emailed to local people. They didn't deliver. All right? Mail is U.S. mail. No matter how you cut it, the words mean what they mean in the generic sense that we all understand them to mean. It doesn't say other alternative means. Now, the Illinois Common Interest Community Association Act, non-condominium, does provide for other alternative methods of providing notice if there is consent provided. Now, a very smart president last week said, does that mean consent from everyone, all of our owners, or consent from the individual to whom we are emailing these notices? And the answer I gave was, I don't know. I don't know. Look at the words. The words weren't clear. That president actually read the words, looked up at me, and asked the right question. I came back the next day. I told my partners. They were laughing. They said, he asked the right question. I said, he absolutely asked the right question. He said, and you answered him? I said, I don't know. I don't know. I won't know until the court rules on it right now. There is no way to say that unless we amend that statute to say consent by the individuals that have allowed it to be sent that way. Which, by the way, was just put into the Code of Civil Procedure for court cases with law firms. Attorneys can be sent notice of things that are being filed or things that are going to be up in court by the opposing party if they have consented. Now, we have the same questions in that statute that are in this statute. The first question on my mouth was, is there any way to generally consent, or do I have to consent in each case and file something that indicates it's okay to send me an email? And what happens if I don't do that and they send me an email? How do I consent? Is my consent in a directory that has my email address? Is that a consent? And we're all laughing about it. We don't know the answer. Nobody knows the answer at this point in time, and not one court in the state has established or answered that question. So we're all walking around scratching our heads. I got something in a case by email the other day, and I ran down the hall and I said to my partner who was also working on it, is this good service? I don't remember consenting in this case. And he laughed. He said, I don't know. I said, are you going to go to court on this? And he said, I don't know. I said, well, and so here and we started laughing about it. Now, you're laughing about it, but these are really quandaries. And then the question becomes, if you did go to court and the court did something, did they do it without, could I have it set aside because he didn't go to court, because he didn't want to go to court, because going to court would kind of be a tacit acceptance of this consent form. This is what lawyers do. This is what Mr. Paul did, and that's what these people did in this case. All right? So I don't have all the answers, but I'm one of the attorneys that will tell you I don't know the answer. I just don't at this point in time. There are a lot of unknowns in some of this stuff. So the better answer on most of it is be rigorous. If you ask me for a workaround, I can tell you a workaround. But the first thing is you got to send out the notice. The second thing is you have to have an open meeting. You have to conduct a meeting like they said. Now everybody said, well, does that mean I have to set notices every time I want to have a meeting? My answer is, yeah, there's workarounds. The simple, and then they say, but that means I have to put postage out every time, and we got 600 units times 42 cents or 48 cents. So $300 every time I have to send notice of a meeting. So what I told an association last week is, set up a meeting every week, Tuesday night, 6:30. At first it was like, I don't want to do that. I said, no, do that. The statute penalizes you for not sending out notice. It doesn't penalize you if you've sent out notice and you don't conduct a meeting. You're all getting it. Okay? Now, the usual reaction is, but I'm going to have 25 angry owners standing at a door waiting for a meeting that we're not going to hold.
Yes.
My answer usually is, well, it depends on the configuration of your association. If you got a place where you can put up notices, in this particular one, when I said it, that's exactly, I mean, I almost got attacked by every person on the board. And I said, on the day of the meeting, or the day before, if you know you're not going to have a meeting, put one of these posts up, stands on the floor in the lobby, says, no meeting this week. Everybody kind of looked at me and said, oh, can we do that? Yeah. There is no penalty for doing that. There's no prohibition. There are simple answers to some of these questions that you're all kind of concerned about. If you have places around your property, now one last night they said, well, we got nice property. We don't want to have posts, notification posts. My answer is, it doesn't harm the look. Last week I told them, just go to your various courts and put up a post with a little bulletin board. It's going to be inobtrusive. Put a little plant in front of it. And every week you can put that post, you sign right up there, 48 hours in advance, or put another post up that you're not going to have a meeting, and you've satisfied the statutory requirements. And they've all kind of looked at me. All right? I'm trying to figure out how to solve the problems. Most of the time, boards are fighting the simple solutions. Don't fight the simple solutions. Don't tell me you can't comply. Figure out how to comply. Does that make it kind of silly? Yes or no? Because you're complying. You're giving them the opportunity to be present. You're being transparent on all the things you have to be transparent. I've been told, we send out minutes, we give everybody the minutes, they can look at the books, they can do all the things that they want to do, and my answer is, the court didn't deal with any of that. The court dealt with certain things and set certain standards. Here are the standards, here's what you have to do. Okay? And I want you to do that. So, I actually think I've covered most of the things involved. I think I've told you most of the workarounds that if you think about them, you can do. The one horrible hypothetical that I haven't covered is the financial stuff. And I can beat him up. But we have had some pretty significant emails and letters and discussions. And I would tend to say that Jim Slowakowski and I have probably spent 20 hours of time trying to deal with the one thing that the court said that drove the accountant crazy. One of the accountants that has been doing this for almost as long as me, and then drove us crazy until we figured it out. All right? Part of the case had to deal with the association's declaration said that at the end of the year, you were supposed to give an accounting to all the unit owners of all the income and expenses with some detail of what that was. All right? And if there was a surplus of funds, you had to refund it to the unit owners. And if there was a deficiency, you had to pass a special assessment to collect that back from the unit owners at the beginning of the year. Now, the board president testified on a lot of things, it seems, but she testified on a couple of things as follows. One of their defenses, by the way, was we've been told by our attorney what to do and what not to do. On the witness stand, what came out was the president had never talked to the association attorney, had no written opinion on any of the things that they said that they were relying on the advice of attorney for, Her representations were predicated upon a statement from some prior board members that their attorney had told them something years before. That's the facts in the case. Now, is that really advice of attorney? No. I will tell you, a defense to breach of fiduciary duty is advice of attorney that you follow reasonably. If you get advice that you know is silly or is in conflict with specific provisions of the act, and you don't question it, and you accept it, and you act accordingly, you're not acting in a reasonable and prudent fashion, and you would probably be guilty of breach of fiduciary duty. If you follow the advice because it seems to make sense and it's wrong, and the court rules it's wrong, you're not going to be in breach of fiduciary duty. It's a defense. In this case, it wound up not being a defense because, you know what? She didn't have any advice. She just made up her mind. Somebody told her somewhere. She didn't do her job. She didn't do her due diligence in figuring out what her job was. She just went off. And her excuse was, I had advice of attorney. Now, can I criticize the attorney that prepared her? Wow. Okay. Now we get into the financial issue. This whole business of a surplus and what you do at the end of the year and not showing records. The court basically said you have to keep accurate records of your finances. Accurate. You have to have a budget, and you have to follow the budget, and you have to have a detailed breakdown of that budget. You have to have reserves, and you have to allocate your reserves in specific categories that make sense. And I mean very specific reserves, not a general reserve. The court also said, and it's a wrong statement. Well, maybe I ought to put it another way. On the witness stand, she was asked whether she commingled funds. That was kind of the question. Now, to me, as an attorney that understands some of the financials, that has a specific meaning. Her attorney should have known, and her attorney didn't prepare her for the term commingled funds. Commingled funds has a specific meaning, and that is that you're taking your money and putting it with someone else's money. That under the Condominium Property Act is prohibited, except in one case. It's allowed when you have a management company that has a disbursement account. They can take all the monies from all the associations, put it into the disbursement account along with everybody else's money, and write checks against it. But they have to be able to track it. They have to have, you know, accounts receivable, accounts payable ledger, everything has to be in there. They have to be able to track it. You have to know what your money is that's going into that dispersing account. They actually used to have it, could be a dispersing account, it could be a receipt account. All the money went into one account, then they had to try and figure out how to divvy it up. And after a while, the banks gave up and said, no, separate accounts. So we don't want, you know, that association's account to get your money or your money to go into that association's account. Set up a separate receipt account. And now they have it, most of it's done in banks, not all of it. Some management companies haven't gotten to that point at this point in time. I don't quite understand that, but because it's available and it's free, and all the banks are doing it, so it's the right way to do it. And the dispersal account is the one place where you can commingle. And it's allowed specifically in the condominium property. So she was asked if her money is commingled, and she said yes. The question was in the context of, do you have a reserve account? I don't know, I think so. That was her answer. Are you sure? Well, I really don't know. Well, is the reserve money commingled with the non-reserve money and the regular budgeted money for expenses? Oh yeah, I think it is. You understand what just happened? You used the wrong term in a particular context. Because it's not commingling to take your money and put it in a different account. But she used and she specifically was asked, did you commingle your reserve money with your non-reserve money, with your budget money in the budget account? And she said, yeah. Well, Judge Sophia Hall made one big mistake right there. She said, that's a breach of fiduciary duty. You can't commingle. Here in the statute it says commingle. Nobody pointed out the other provision that allows commingling, and nobody pointed out that commingling means putting your money in with somebody else's money. Okay? She ruled that to be a gross breach of fiduciary duty. Okay? Next question that was asked in the case was, did you have a surplus? The president said, yeah, we had a surplus. Did you give it back to the unit owners as required in the declaration? No. We did a resolution and we transferred it into a reserve account, which, by the way, everybody does. Every management company does. The accountant involved, who was really a very competent accountant, said, in his estimation, we think he was the same accountant for 2,800. He said, from an accounting point of view, they got an A+ in the way they handled their money. The only place that they got an A+, but they got an A+ in the way they handled their money. They got beat up by the trial court and the appellate court. Why? Because they didn't understand the differential in words. Nobody prepared them. She said, yeah, we had a surplus. Well, and the judge ruled that they breached their fiduciary duty because they didn't return the surplus because they put it into the reserve account. Now, that was where the defense of we relied on our attorney came in, and we relied on our accountant came in, which she couldn't prove in either case that was true, which further hurt her and hurt the case. And for you to understand the difference, it gets pretty complicated now, and a pretty sophisticated and esoteric. When an accountant does a financial statement at the end of the year, they will take all the income and all the expenses in the operating account and look at all of that, and they will ignore, for all practical purposes, money out of the reserve account that was taken, that was used to meet some of the expenses. At the end of the year, they'll say, okay, here's all the money you took in, here's all the money you spent, there's a differential. That differential, they almost always call a surplus, if there's money left in the account. If there's money not left in the account, if it's negative, they'll call it a deficiency, but there's never any left, not left, because they usually have taken it out of the reserve and put it into the operating account, so there's not a negative in the operating account, it's only a surplus. Every accountant will tell you that they need to take that reserve and transfer it into the reserve account, into the account for future expenses, in order to prevent that from being taxed as income under the under certain sections of the Internal Revenue Code. That was the money she was talking about. It is called a surplus. The declaration said, and you got to look at your declaration. The declaration said, you take all the income that came in and all of the expenses and the reserves. Now, they don't use the term right, but it's all the income, expenses, and reserves. And any excess of income over and above all of these expenses, you have to return. Any shortfall, you have to do a special assessment. Well, you can tell me, but that's the same as what I just said. My answer is no, no, no. Because it said income, expenses, reserves. What they meant was reserve expenditures. So if you take the reserve expenditures that you used for paying the expenses, in their association, let me put it this way, they showed a surplus of about, as I recall, there were two different numbers, so I don't want to misremember. I remember one number of $36,000, I remember another number of $232,000. But they had about $900,000 in capital expenditures that they had made during the year. Where did that money come from? That money came out of the reserve account. Okay? Now, if you look at the financial statements that the accountant actually provided us, not in that case, in another case, there is actually a place where the accountant actually balances out the income, the expenses, and the surplus expenditures. And what it winds up being is a zero number. So the number under the provisions of the declaration, if you understood what I'm saying, the number really was zero. In other words, all their income came in, they had operating expenses and reserve expenses, and they took money out of the reserve to pay the reserve expenses that weren't available from the operating account, so that the differential between expenses on a reserve and all of the operating expenses wound up being zero. From an accounting point of view, that's not the way they look at it. They're showing an operating surplus because they don't count the monies that came out of reserves. And they want that surplus in this year transferred, but that's not what any of the declarations say. And that president wasn't prepared, so the president said, we have a surplus. The judge understood that word to be the word of the declaration. She said, we didn't give it back to them, we transferred it. Breach of fiduciary duty. The word of the declaration says you give it back to them. But we did what our accountant and our attorney told us to do. Well, it's hard to do what somebody tells you to do when your governing document tells you to do something very different, and it's on its face different. It doesn't say, or do what your attorney will tell you to do. It says, give it back to the people. You didn't do that. You're breaching your duty. It's kind of that simple, if you really think about it. So when you understand what happened, you had a lot of half-facts, a lot of things that went together that weren't quite right. And sometimes, like in this particular situation, you almost have to sit down with the attorney and the accountant and the manager and say, please help me understand this. Help me explain it. I will tell you, we spent hours on the phone on this issue. And when we all got done, it was like a burden was off our shoulders. It was like, you know, at one point in time, we got an email that said, is this okay? And the answer was, yes. Yes. It was that simple. The answer was yes. We looked at the numbers, the answer was yes. And thank you very much. And we were done. Correct? We were done. Because we looked at the words and we saw the difference between what the accountant was doing at the year-end financial statement and what the declaration asked us for in terms of what we were to do under that declaration. We didn't have to return any money. We still said, do the resolution transferring the surplus to the reserves to cover the expenses. We did all of that stuff, but by doing all of that, we wound up then meeting all of the standards that was necessary in the declaration so that it balanced out and there was zero and there was nothing short. We didn't have to do a special assessment and we didn't have to put any money back. Manager, you can communicate with the manager by email. Now, maybe the question is, can you send copies to everybody? The question was, can we send an email to the manager saying, be sure you have this on the agenda for the next meeting? And the first question that I have is, I'm not sure that's really talking about board business. It is, but that's all you're asking them to do is make sure that things are on the agenda for the meeting. Those kinds of things, I think, are all right. Can we make sure we're addressing the following subjects as that? Now the question is, do you not name all the board members and send a copy to all the board members when you send it out? And my answer is, I'm not sure that that's really conducting the kind of board business that the court was trying to stop in that case. What the court was really focused on in that case was, they were voting by email. They were voting on stuff. They were making decisions and they were ruling on stuff. So, did it get expanded? For all practical purposes, we've said to boards, stop conducting business by email. Because they've said, any quorum of a board is conducting business by email. So, part of the things I've said to you is, if you and another board member are talking, and you're not a 3-member board, you're not a quorum. And even if you're talking about the landscaping or the budget or any of the things that have to be repaired or a violation, you're not conducting board business, because it's only conducting board business if you have a quorum of the board and you are discussing things. And what the court said is you can't beat the system by sending around email blasts to everybody and looking for a response. You can't conduct board business and vote by email. We don't want that done. But that doesn't mean that the president can't send an email to the manager saying, we want to make sure that you put this on the agenda and CC all the other board members, because you're just making the board members aware you're not having any discussion. If you ask me whether I'm shaving hairs there, my answer is yes. It may be better for the president to send that, and if some other board member independently sends it, and it's repeated, it may get repeated. Managers may get angry. I mean, I get sometimes 2 and 3, and I try saying to presidents at the boards, listen, designate one person to communicate with me generally, so that we don't get 14 copies of everybody. And then, you know, what am I going to tell you? You know, if you're talking to the board and you happen to say to one of the board people, oh, I sent an email to the manager saying, make sure that this is on the agenda. Can you tell so-and-so board member? Oh, that's okay. And you know, you could meet it with a couple of them and you could say, I did this. Are you discussing board business? Yes, but you're not. And if you ask me where the fine line is, my answer is be reasonable. Understand what the fine line is. We're trying to just make sure that everybody is on board of what's going on. I don't think you're really conducting business. Conducting business is talking about business and making decisions, talking about what your problems are. And I use the other example of a meeting I was at last night. One of the board members said, I got a problem with this paragraph in this contract. And the president said to me, can he and I talk about that paragraph? Because I want to look at it. I'm pretty good at contracts. That's part of what I do. He was a high-level executive in this public company. Contracts didn't bother him. I could, talking with him, I pretty much got that clear sense and message. I said, absolutely, it's not a problem. You know, one board member said, I got a problem with this paragraph. Can you help me address this? You got 2 board members out of a 9-member or 5-member board. They're not conducting any board business. If you tell me, but it is board business because they're looking at a contract, my answer is, I'm not sure that that doesn't fall within the exception anyhow, because you're dealing with some potential litigation issues, but more importantly, it doesn't fall within the parameters of what the court said you're supposed to stop. All right? What the court said you're supposed to stop is conducting business by email. All right? It is conducting business, but it isn't discussing among the group as a whole all the issues that are being discussed. It's one board member reaching out to another board member or the president saying, I've got a problem here, I need somebody to talk to, I need somebody to look at this, can you look at it? And that's fine.
And Mark, the key is you're describing less than quorum.
Less than a quorum.
Less than a quorum. All day long, less than a quorum.
Less than a quorum. If you ask me whether it's going to change at some point in time and they're going to expand it, my answer is, I hope not. I don't think so. I think they've tried to limit it to stuff like that. If you ask me whether there's going to be legislation that's going to change that, my answer is not for another 6 months, and don't count on it. I think you're going to have problems because I think the legislators are going to like a lot of the things that were in here. They want more accountability, not less. Yes?
I have 2 questions. The first question is, are committee meetings open? Are they required to be open, or can they be open?
No.
No, they're not required. No, they're not open.
Required to be open.
But you still
You don't have as long as you're in a quorum of board.
So it's not quorum board. Okay. The second question is, if at open board meetings, if there is no open forum, when does an owner have the opportunity to voice their opinion or their concern about a certain issue?
Well, I'm not sure I understand why there would be no open opportunity.
Well, we were both, did you say that at a condominium board meeting, there does not have to be an open forum?
No. Yes, I did say that. I guess I misunderstood what you meant by open forum. You mean a forum where the owners have an opportunity?
No, I'm saying, let's say it's just a regular call board meeting.
Yeah.
Okay, and there's some issues or whatever, but yet the owners are not allowed to speak out because the president or whomever has decided there will not be an open forum.
Correct.
So how does an owner go about doing something about getting their opinion or their concerns heard?
that they support it, right?
From a legal point of view, they have no voice at all.
I understand they have no vote. I
They have no
do.
voice, they have no vote.
That's two different things to say.
Right.
No voice.
From a legal point of view, I'm answering the legal, let's talk about the practical, which I think is important.
Well, but I mean, if our precedent says there's not going to be an open forum, and there's no forum, and like the night we had a meeting, and I had to, I took the opportunity, as soon as he was during the meeting, I said, I have something to say. But by then, it was over and done with.
You have no right to do that. You have no right to do that.
And that's
That's assuming the people that were elected know what the hell they're doing.
Well, I understand that. That's what I'm telling you what the rules are.
Okay.
You have no voice, you have no vote. You have no right to interfere. You have no right to
No, I
interrupt.
would not
In
interfere.
many cases now, because of problems like that, we have rules that say, if you disrupt the board meeting, the board can stop what it's doing and instantly hold a hearing and a meeting, and it goes fine. You can do it right there.
No, these
And we've started doing that in associations where the unit owners are just disruptive. It's the only way to quiet it down.
But if I start maybe add from the management side first, and then it does tie into what we have another legal right, and Mark can talk about, we would always recommend to our board that we have an open forum. It does need, however, to be controlled, right? And it is something that the board can decide, yeah, but as Mark said, it's not a requirement to have.
I understand.
But we think, we do recommend it, but it does need to be controlled, and that's where you work with the management company to
It
control.
was all about the management.
Well, okay, well, now let's move on to slightly some other related issues there. You know, I'm sure Mark's been talking about the fact that, you know, a percentage of the ownership can call for an ownership.
Oh, we were talking about that.
Okay, and you do then, and maybe take it over from what's the owner's recourse, okay? And that's elections, and that's also calling 20% of things that allow them, owners, maybe I'm going in the wrong direction, but just things that allow owners to object to certain decisions, but they're not part of the board meeting.
There's very little that a unit owner can do, and only in certain circumstances, that are specifically spelled out in the Covenant Property Act and the Oregon Non-Profit Corporation. From a practical point of view, my answer is if they shut you down, you almost don't have any recourse, other than, as Paul was saying, to try and get petition unit owners to call for a special meeting to remove the board. If you're going to call for a meeting for the purposes of petitioning the board to remove management, you can call that meeting and you can have that meeting held, and it has no effect. The board has no obligation to comply with the unit owner's vote to remove management or anything, or to do anything. There is the only times you have is the right to remove the board, if you have the necessary percentages, if you call the meeting properly, and to vote at the annual election, and to object to certain expenditures if it meets certain criteria under the condominium property. If they pass a budget that is more than 115% of the last annual budget, that if you can get 20% of people to object to it, and there aren't exceptions to that, then it is an exception. You can call a meeting and you can basically set aside the budget if you can get more than 50% of the people in your association gross to vote on that. I've never seen it happen, but if you don't get 50%, it's a ratification of what the board did. So it winds up coming around the wrong way. You know, you lose 100% when you do those kinds of moves. The statute is meant to set a standard that gives people the right to protest when you have enough of a group. But if you don't have enough of a group, you're kind of stopped from going any further with some of the process.
So it's just at the end of the day, it's the election where you get the voice your concerns, and that is the power of the board.
And what you do sometimes, but you know, that's the way. And
That's the majority, not every homeowner represents the majority.
Question about the budget. Speak about
What I tell people when they have that is, if you have a management company, whether you like it or not, or whether the issue is involved with them, you write a letter to the management company asking to present it to the board for their consideration. Don't just write a letter complaining. Write a letter that has some issues that need to be resolved.
Right.
Write a letter that's complaining, you're just complaining. If you write a letter and say, here are issues that haven't been resolved, I'd like them addressed and resolved, then hopefully the management company will present to the board and let the board consider it, and the board will consider it. I can't tell you they will, but that's the way. And if you don't have a management company, you do the same thing by sending something in writing to the board or the president of the board. If you're really concerned, basically, you get a petition and you get it signed by 20% of the owners, and you present that petition. And you kind of do, then you start politicking with an eye toward getting some members of the board removed at the next election, getting yourself or some people that are like-minded onto the board to start doing the things that haven't been done that you believe should be properly done. But those are all steps along the way. Okay, yes. Yes.
About the budget, do you have to call a meeting for the homeowners to form a budget, or can just the board of directors do it?
The board decides the budget. You don't always want to participate at all unless your declaration says otherwise. There are some declarations that have said that. I have seen it where the unit owners vote on it. I will tell you that under SECA, I don't think that's a requirement anymore. For non-condominium, I know it's not a requirement under condominium. Unit owners have no voice or vote in passing the budget. You have to present it to the unit owners every year. It's an obligation. You have to send it out, you have to vote on it at a meeting, and you have to pass it.
But they don't have to be present when we work on formulating the budget.
Yes, because there's a.
Well, now it's an open meeting. Now it has to be an open meeting. All right? Now, if you work on it with the management company and there are two board members, the president and the treasurer, are working on it with the manager, that's not, you haven't met the standards. And then you present it and you discuss it at the open meeting, and then you vote on it. All right? Or the management sends it out to all the various board members. Maybe there's a committee. You have a committee that's working on the budget, one or two board members with the management company. You do the kinds of things that I talked about doing in order to create an environment that allows you to work on the budget. Very frankly, most associations that are managed, you and I really know that the management company comes to you, here's what we presented, here's last year, here's this year, here are the things that we've looked at in terms of reserves, here are the reserve requirements, here's your reserve study, here are the things you need to address. They go over usually with the president and or the treasurer. It's pretty much presented to you. If they're not doing that, you need to find a different management company. Very frankly, because these are all the things that the management companies that know what they're doing will do in the normal course. They'll make lots of recommendations. They'll see what's out there. They know what's out there. They know what landscaping has to be done, where it's going to be coming from. And sit and talk with you, get the sense of what you have. You kind of will know from what the board history is and from what you can expect. You kind of, the management company will know because they'll have talked to the various board members at different times. So you're pretty close to having a budget in place. You and I both know that in most instances, unless you have some board member that's off in left field, and I've had that, and we've all had that, it's going to be this way. I hope I'm not speaking out of turn, but I once had a board member who was a retired realtor. It was a 5-person board. It was the only man on the board. He was a retired realtor. I won't tell you his ethnic background, but the bottom line was that he said the budget, his portion of the assessment in his condominium could never be more than a third of his Social Security check. That was his criteria. And I came to a meeting and said, you're in breach of your fiduciary duty to this guy. You imagine that? I mean, and it wasn't a big Social Security check.
Trust me, we've all dealt with homeowners and board members who will quote the law, and that probably was quoted.
And let's say quote the law, they quoted it improperly. Right? They quoted it improperly. Last time somebody did that, they told me who the attorney was. I said, you have his phone number, I know him very well. And we called him, and he said, no, that's not quite what I said.
Marshall makes a great point about your budget. They're all coming out. We do recommend two members of the board work with the manager in refining and refining. But, you know, even our intent is, you know, well before you get to the board meeting, we're going to send it to the board member, and we'll get some individual feedback on it. But your final decision should be made. We'll be at the I did want to add to extra board meetings, right? So we do have people trying to set up the every Tuesday night. You know, yeah, it's a little sketchy right now. We also have encouraged our board, if there is an issue that they haven't been able to delegate to management, there is nothing wrong with having a 10-minute board meeting. Proper notice, it's one item on the agenda, you have to go through the formalities, call the order, and all that. One piece of new business or old business, and we make the motion, we all go home. 10 minutes. Your management company doesn't even have to partner. If you particularly call it in your own building, or you're calling it there, right, just want you to give it notice. I did one in a parking garage 2 weeks ago, 15 minutes. Somebody else did it in a lobby, 8 minutes.
That's the question I
Can
have.
you move back, sir? Move back, because you're projecting there and missing us.
Oh,
Sorry.
Can I add to that so that you know, one of the things I didn't talk about, and one of the things that has come up is, there are certain things that under the Non-Profit Corporation Act are not being allowed, like electronic participation in board meetings. All right? Skype. Put a computer on the desk. I now have that where a couple of board members, I got one that's a snowbird. The person is not here, the person, they put up a tablet on the desk at the board meeting, turn around to the unit office, facing the unit office. And the board member is on Skype, sitting there at their desk in Florida, but available to visibly see the people, you can see that person, so they know it's that person, and they're participating as a board member in that meeting. It's allowed. The next question that I was asked was, can we do electronic communication if we, and meet quorum requirements at this point in time? And the answer is, I don't know the answer to it. All right? And so I tell people, have a quorum by people present. But if you want to have other board members there and they want to be there, and you cannot be there, you can use electronic means. You may have to pass a resolution in order to do that under the Non-Profit Corporation Act. Any attorney that knows what they're doing knows how to pass that resolution, so you can do that. You can do it in the condos, you can do it in the non-condos. We're all okay with doing it. Everybody understands that. All right?
you could phone in quorum in those situations. But
I'm a little worried about the quorum, but if you got the quorum, if there are one or two other people that want to phone in and want to have a cell phone on the desk, and they can participate with a cell phone. A couple of ones when I said that, is we're already doing it, we're using Skype, we're putting the computer on the desk, you can see the person, they can see us, they actually can see the audience, we actually turned it around to the audience, and the audience can see the board member, and the board member talked to the audience instead of the other board members. And it worked like a charm. They were just thrilled with it, everybody was happy. Everybody was participating. Nobody was grumbling about the board member that isn't participating because they live in Florida. That board member participated in the affairs of the association. What business? Had everything they needed to have. Everything was emailed to him. He knew exactly what he was doing. It was a great thing. I was kind of surprised. So Skype. Does everybody know what Skype is? Enough of you know what Skype is? Talk to your grandchildren. Yeah. Yeah.
Question, you mentioned 115%, and we had a little debate in our condo with regard to that, and we did get a ruling. And they said because of, with our assessment, it's only part of ours is with the umbrella association, part is our association. But because we collected for the umbrella association, disperse it to them for all the different things under for the landscaping, the pools, the golf course, whatever, that we could go 115% of both of those budgets. Because we collect them, but we don't have any say in the one budget.
The Master Association budget is not considered. We didn't analyze it at 50%. Now I know why we thought.
Yeah.
Now I know what the conflict is.
Yeah.
Okay?
Yes.
Just tell me against. You had a question.
No, I wasn't.
Okay.
Would you please repeat what you said about there are times when the officer and director liability insurance does not cover a trustee or a board member?
You are in breach of your fiduciary duty under the law. Your insurance that you have for officers and directors will not cover you. It doesn't cover gross breach of duty. And breach of fiduciary duty is basically gross breach of duty. And it won't cover you. And your indemnification provisions under the Not-for-Profit Corporation Act, and in most declarations say you're indemnified unless you're breaching your fiduciary duty, you're acting outside the scope of your authority, or you're grossly negligent in what you do. And breach of fiduciary duty falls within one of two of those three things, in my opinion. So, you know, it's a high standard. That's why my comment to you is, if it says mail, it means mail. You can't decide that I'm not going to follow it. And to a certain extent, we as attorneys are guilty of basically saying, it can't mean that in today's world. And the court basically said, it does mean it. All right? Would you have been breaching fiduciary duty if the attorney told you mail can't be mail, and you had an opinion and said that? I think you would have been okay a month ago, 6 months ago, not 6 months. All right? That's why I'm telling you, some things I don't know, some things I probably don't do. Yes?
What about the homeowner after their board and management company is not doing
No, what you said?
If the board and/or management is not doing their fiduciary obligations, what happens if they're not following the declaration, or they're not following the statute, and they're not doing what they're supposed to do? Well, my answer is nothing happens unless somebody files a lawsuit.
But is there an organization, I mean, is there something like the state attorney?
No. State attorney couldn't care less about private corporations and what goes on unless there's money being stolen. And breach of fiduciary duty doesn't equate with that. There is a dividing line at this point in time. Yes.
With the closed meetings, the executive sessions that we can have, I understand that and go into the open meeting to make your vote. But can you have the closed session without opening a meeting? Let's say my board meeting's next week, but we want to discuss the thing tonight because it's a litigation thing, and then we'll make all the motions in the open meeting a week later. Can you do that, or you have to call a meeting, go into executive session, and come back into the meeting?
In my opinion, you have to call a meeting.
Okay.
You have to meet all the requirements for a regular meeting, and you have to open the meeting and then adjourn into an executive session.
Okay.
And then in the executive session, you have to come back out of the executive session,
right, and then
reopen the regular meeting, and then if you don't have any other business, you adjourn.
Okay, so we can't have
But you should have a notice. Now, I was at one the other day, and one of the things that kind of came up, they said, what happens if we're meeting with the attorney? And my answer is, I'm not sure I know the answer to that. All right? From a litigation point of view and from all the case law and all that, meeting with your attorney is attorney-client confidential, attorney-client communications. It's kind of an exempt act. But I actually went to a meeting at the association clubhouse. And because I went to a meeting at the association clubhouse and they didn't come to my office to sit with me, I said, if you were to do this over again, I think you ought to send out a notice saying, we're having a meeting, it's to discuss issues with the lawyer. We consider it to be, we're putting it on the agenda, we're sending out notice, we're going to call a meeting, we're going to go into an executive session to discuss matters with the attorney, and we're not going to discuss anything else. When we come out, we're going to adjourn. All right? So you've complied with your requirements by sending those. In this association, you put it out on the posts where you have to put it 48 hours in advance. It's all you have to do. If you have it set up for a meeting, you have it set up for a meeting, the people that come, you tell them when they come, sorry, we're going to go into executive session. We're not going to conduct any business other than to meet with our attorney, and we're done. Now, what I've done is kind of belt and suspenders. All right? You've given everybody notice, you've set all the standards, and you told them that you're not going to do anything that they have a right to be at. So you're not going to get anybody angry, you're going to meet all the requirements. And it doesn't take an awful lot to do that, depending on your configuration. That's why when I hear people say, but we're a big association that has, you know, 10 acres of property and you've got cul-de-sacs and courts. At some point in time, the simple answer that I'm going to give you is set up posts and put up signs so you can post them. If you've got a group of mailboxes and you can post a little bulletin board above the mailboxes in some of the areas, and there are some areas that have that. Designate that as where you're putting notices and do it in the rural areas. If you're a mid-rise or a high-rise and you got an individual building, put it on a bulletin board in the lobby. You're better off giving notice than not.
Right.
It's always safer, all right? And people say, well, what did you talk to the attorney about? The answer is, I talked about, what we talked about was attorney-client communication. We can't tell you. And, by the way, that's what this Whispers is all about. I gave you 2 other brochures. One is Whispers, all right? And it's not as comprehensive as it should. One of the 2 other brochures is a detailing of what it means to be board responsibility and what your duties are as a board person. All right? I try and explain that you're running a business and you have duties to that business. And those duties to that business are different than your duties to yourself, and your obligation is to that business, not to yourself. All right? The second is, if you're talking about confidential information, attorney-client communications, attorney-client discussions, it's confidential. You don't go home and tell your significant other, you don't tell your neighbor, you don't tell your attorney or child attorney, you don't tell anybody. The phone message I got today was, you need to send out a memo to everybody on the board because at the next board meeting, things were said that were discussed in the meeting with you. And I think you have to reinforce that to the people that didn't bother to read this, that you don't go back and talk about confidential stuff outside of the group that's entitled to have that discussed, which is only the board members, no one else. Confidential stuff is confidential stuff. You don't carry it beyond that location or and among that group. No one else.
I'd like to thank Marshall very much.